Welcome back to another edition of Between Two FARS. I'm Warneke Miller, and it's my pleasure to introduce you today to Andrew Falcon. He has been an attorney for over 30 years and started out in private practice, but 28 of his 30 years have been spent here working for NASA. He did 2 years over at the Office of Government Ethics, but has spent his time here in a variety of positions, including spending time at headquarters as the Associate General Counsel for General Law. And then since 2012, he's been the chief counsel over at Goddard. We've brought him in here today to talk about risk management because this is a very important aspect of our legal practice, but it's often been overlooked. And Andrew's got some fantastic insight on risk management. Andrew, can you just help us understand an attorney's role in the risk management process?
Sure. Well, first of all, I mean, the legal practice is fundamentally about risk. It's what we do. If there was no risk, there would be no lawyers. And I figured this out. I've spent a lot of time over the years talking to non-lawyers about what we do in the legal office. And particularly at NASA, I think we've always been a little bit of a black box for the clients. Stuff goes in, stuff comes back out again, what happens? And the way I figured, this was probably 25 years ago, I figured the way that you can explain it that immediately makes sense to NASA and people anywhere is we're the Office of Safety and Mission Assurance for the business side of the house, right? It's that simple. We manage non-technical risk for the agency. Now that can come up in a lot of different contexts, right? It can come up in the context of, an ethics question. It can come up in the context of a procurement question. It can come up in the context of litigation. It can be anything, but it's all the same thing. Litigation obviously is by definition a liability risk, right? So effectively we're trying to control that, mitigate it, eliminate it if we can, but at the very least minimize the impact on the client. But the same thing is certainly true of all the advice and counseling we do, all of the audit and compliance type stuff that we do. I mean, if we get a bad audit, that's a risk. If we have an Anti-Deficiency Act violation, that's a risk. So when you get right down to it, that's 100% of what we do. We don't do anything else. We just do it in a specific context.
So what is it that an attorney should be doing? What process do they go through when they've got a new case coming in? If they're thinking through the risk management lens, what is their job?
Sure. So this gets really to the core of, the nuts and bolts of a legal practice, right? First thing you have to do is you have to assess, based on the facts that you got, how big a case it really is going to be. Is it and why, right? Is it a big case because there's a lot of money involved? Is it a big case because there's a lot of potential programmatic impact involved? Sometimes very small dollar value cases can have a really big programmatic impact. I had a construction case many years ago that it was about $150,000. We wound up doing a termination for default and sustaining it at the ASBCA, or actually the NASA BCA. It was I think it was the last case NASA BCA ever actually handled. But the point is that the impact of the case was they needed to move the Hubble First Servicing Mission corrective optics package into that building, right? And so, it wasn't about the lawsuit. It was about the impact on the program if it didn't get resolved, right? So you always got to look for those first and second order risks and figure out what they are. And then you can figure out, do we try the case? Do we pretend like we're going to try the case, but really we know we're going to settle the case? And all the stuff lawyers do, right? Sometimes your views will change. You get some good discovery in, and all of a sudden you realize you have a stronger case than you did, or a weaker case, or whatever. Sometimes it's a dog from the start, and you kind of have to explain to the clients, no, we screwed this one up. We need to make it go away, right? So all that stuff it's foundational to what you're doing. When you're engaging in discovery, what you're really doing is assessing risk, right?
So your job is to sort of assess the risk and provide options for the client, but that's an ongoing responsibility throughout the litigation as new information comes in?
Yes, and in fact, this is something that I know lawyers are all over the map on, and everybody's equally right. I mean, it's not that there's one way to do it, but when you say assess the risk, provide options to the client, I think we all agree on that. The question is, at that point, do you engage in a little bit of internal advocacy? Right? And to what extent? It does have to be the client's decision, but honestly, we understand it better, right? And so in practical terms, what does that mean for the client's role in all of this? Well, they're the decision maker, but I always took the view that I was going to prod a little bit more. I think some people are a little bit more on the more laissez-faire, clients call, I'll do what they want. It's all valid, but do it deliberately, right? Yeah. Instead of devoid of conscious thought.
So some of these steps you take for mitigating the risk includes not only advising the client, but also maybe running the gamut internally to open up other options or to get people to think more seriously about some of the options that are on the table?
Oh, sure, of course. And in fact, that really should start before you got sued, right? If you've got a good client relationship, and the whole point of being in-house counsel, right, the entire point is we're not a law firm. We don't come in to fix problems after they happen. Hopefully we fix them before they happen, right? And so hopefully you're doing exactly what you just said, right? You're just doing it every step of the way. You're doing it from, before requirements definition gets started, right? So give you an example from back when I used to review contract files. We had a long series of running arguments in the office about how much review you need to do, right? And some of these files would come in and you get a statement of work that was, that big. Do you even read the statement of work? I mean, how many people out there review the statement of work when the package comes in, right? I mean, I'm guessing it's not 100%. In fact, I'm guessing it's not 50%. But the problem is you start paging through it and you're like, it says right there, all these things are written by committee. It says right there, comply with paragraph, 1.2.3.4, and there is no 1.2.3.4 because some other person took it out in editing. That is a claim, right?
Yes.
It's going to be a claim. At least in the construction world. So it's that kind of, and I'm picking on procurement because this is between two FARS, not between two civilian personnel law manuals or whatever. But it applies to everything we do.
Yes, it does. What do you say to that client that comes to you and says, I want you to get rid of the risk. I need you to eliminate the risk for us. This is too important a program. We need zero risk. We have zero risk tolerance. How do you address them?
I'd say don't get out of bed in the morning. I mean, so that's a really good point too, because it's not just about the client, it's also about how we approach it. There is always a rule in the government that says that you can be interpreted to prohibit anything, right? I mean, we have so many statutes and regulations, and then you factor in NPDs and the financial management manual and all that stuff. You can say no to anything if you want to, right? I mean, so the question is, and that's the safe thing to do, right? And it's the easy thing to do. It takes a lot less work. The fact of the matter is that then nothing gets done. So as soon as you make the decision, we're going to get something done, you're taking risk. And then it's a matter of what your risk tolerance is. Well, can you even answer that question intelligently if you can't characterize the risk? Right. And so this is where the difference between us and OSMA, where my analogy falls apart, right? They can sit there and they can look at triple E parts reliability, and they can look at statistical sampling, and they can go audit factories, and they can do all that sort of thing. We're dealing with the vagaries of individual human behavior, right? For fans of, the Asimov Foundation trilogy, everyone is the mule. Right. I mean, just the unpredictable nature of what we do. I don't think I ever felt I could say a case was more than 70-30, right? I don't think I ever said a case was 80-20, even if I was very confident, because we just don't have those tools. So how does that play out in advising the client? Well, you got to have an idea what the client's risk tolerance is, and you've got to express those risks clearly and expressly. I just think there's no other way to do the business with integrity.
Thank you, Andrew. These have been some very salient points on the concepts of risk management. I'd like you all to join us again next time, because we're going to continue our discussion with Andrew and begin talking about legal risk and legal review thresholds and how those interact with one another. So join us again next time between two FARS.